have any way of calculating that. If it is penal, anyone who is wrong, we have penalty unit by which we calculate how much you should pay because you have wronged the state. When the state wrongs somebody, don't you think there is a need? Oh, no. So, it's part of the question, Chair. So, don't you think there is a need for us to have a unified body of laws that helps us determine what somebody should be entitled to under those circumstances?
Honorable Chair, I still stand by my earlier position that the common law practice where judges are given the discretion to determine how much an applicant is worth in terms of compensation should be maintained in the meantime. Thank you.
Very well. Since you maintain your position, I may also have to make it very clear that I also disagree with that position, because I believe that in a democracy like ours, we should be able to establish a very clear compensations regime where when the state wrongs an individual, the state will be made to pay, and there is a clear way of calculating that. Now, the second major question has to do with death sentence and what your views are on death sentence. Now, when you look at the commission, the Constitutional Review Commission's report as far back as 2010, and you look at the government white paper in respect of that report, it is clear that as a state, we have agreed that there is a need to abolish death sentence. As a Deputy Attorney General, what would you do in your position to support that call to ensure that we remove death penalty from our statute books?
Thank you very much, Honorable Chair. As to whether Ghana has agreed that death penalty should be abolished, it's something that I cannot confirm. But I know that there are various groups agitating that kind of stand, that Ghana should abolish death sentence. Speaking for myself, as a human rights activist, human rights lawyer, I hold the view that life is precious, but that doesn't mean that you must also take someone's life. I'm a realist. I'm a positivist. If you look at some of the murders that we have, especially when it comes to even robbery with murder, the callous manner some of them carry out those actions, I think that we need to hold on for some time. Not at this stage. I equally also hold this view that as you have in the US, if this honorable house, together with other stakeholders, may want to venture into grading murders, some of them are subscribed to the execution of their full execution of their sentences. If it's murder, they have to be killed, they must be killed. At times, it sends some kind of signal to others that it doesn't pay to kill. But so far as we have it now, people are sentenced to death, they are in prison at Sawam. Some of them, under some circumstances, you may say, you may want to sympathize with them. But there are others that I think, if we were to scrap their sentence, we may have more murders. So at the moment, I don't subscribe to scrapping it. I know that Amnesty International and the honorable member, Sosu, is a human rights activist, and he's interested in having that one scrapped. My colleague, the other deputy designate, Diana was there last week, and she's of the opinion that we may want to go that way. I hold a different view. I don't know the view of my boss, the Attorney General, but I think at this stage, we need to keep the laws in our status books, and if need be, carry out some of the sentences.
Very well, because it's still a committee of record, and you said you don't know exactly the position of Ghana, and I just want to make reference to that position so that the record can capture it very clearly. When you refer to the case of Dexter Johnson versus the Republic, it's 2011 to Supreme Court of Ghana law at 601. You can see this specific reference at page 702. The Supreme Court, Justice Duche, made it very clear that we've gotten to the time where Parliament will have to take steps to remove the death penalty from our studied books. And this is 1 year after the Constitutional Review Commission had finished its work. And the government white paper on the Constitutional Review Commission's work was also very, very clear. In fact, this was the position of government, with permission of Honorable Chair, if I may.
Not the position of Parliament. When it comes here, Parliament's position will be known. So let him say his view.
No, I'm putting those facts to him so that it will be properly captured, because I believe that death penalty is a major public concern. And
let's proceed with this. We will take that debate when it comes.
Very well, very well, right, Honorable Chair. So I will move to the very final aspect of my question, which I'm also concerned about, and that is has to do with police excesses and police abuse, and abuse by security institutions. We have seen in this country a very, very serious regime of abuses by law enforcement officers. We've had situations where even when a court has, even when there is an injunction pending, you would have an institution, maybe like IOCO or other institutional security agencies, disregarding that orders and going ahead with arrests. What would you do as a Deputy Attorney General to correct these excesses in our system so that law enforcement officers will not become agents of lawlessness?
Thank you very much. The police service, Mr. Chairman, as you all know, has been trained in such a way that they should carry out their activities lawfully. That's how they've been trained. But at times we may have excesses. Ghana is a state party to the Convention Against Torture. Ghana is also a state party to the International Covenant on Civil and Political Rights. All these treaties detail aspects of unlawful arrests. And because by our constitutional architecture, if you look at Article 293, an officer like a policeman who goes about engaging in unlawful arrest, when such an accused person comes to sue, it's the state, that's office. And for that matter, the Secretary Attorney General is here. I'll support him in making sure that officers in the Ghana Police Service are given the necessary training and also be made to understand that Ghana is a constitutional democracy. Mr. Chairman, I also know the opinion of my boss to be that there are instances where people may want to go and engage in unlawful actions or unlawful acts. The state is sued, the state pays. It's time that we pursue actions against such individuals who may want to let the state get into judgment debts. This is what I think I'm supporting my minister, if given the opportunity by this honorable House. Thank you.
Yes, Honorable Bono.
Congratulations, Council.
Thank you.
You love tennis from your CV. And I guess, who won the last Roland Garros last Sunday? Before I shoot.
Unfortunately, for some time now, I've been fully engaged, occupied with this process.
All right. Djokovic did, and he's 19th time.
Thanks.
Thank you. Let's go to legal aid and straight to Article 294 of the Constitution. Are you there? Yes. Oh, okay. You submitted to the committee that you've been involved in legal aid as counsel. And the Constitution requires us as lawyers to at least do some pro bono. What were some of the challenges you faced, or what are some of the practical difficulties lawyers go through in performing this particular function, especially where it's enshrined in the Constitution? Knowing how active you are at the bar, knowing how lawyers practice and what they would want to do in their offices confronted with this provision?
Thank you very much, Honorable Chair. Legal aid is a constitutional provision. Lawyers are trained to also make sure they embrace legal aid. A lot of us have done legal aid cases. The problem has to do with sometimes time management, where a lawyer in private practice has also been engaged by a client. He needs to also attend to the client's cases in court, but he has to also attend to legal aid matters. So there's that kind of challenge. The challenge that I see again is not about the lawyers, even it's about the clients that we work for. There are some of these legal aid clients who come to you, even getting their transportation to come to court is a big challenge. You have to go to court, finish up the case, they sometimes give them TNT to go back to their various hometowns. So it's about resources. And
are you talking about Bekwai or?
Maybe. I'm not talking about Bekwai. I know the Honorable Chair's constituency.
And when I was a young man, I was doing a lot of pro bono cases. See, that's where I built my goodwill on which my political career hangs. So you can do that in your constituency.
Very well. Thanks for the information. So, Honorable Chair, legal aid, I think the main concern has to do with resource allocation and how lawyers also can apportion their time such a way that they can attend to their clients.
I'm satisfied. Since we are going back into 2024 big, as you said, that Trinidad will be back in 2024. I don't know if it's in Sunyani East or in German South, but time will tell. Let's look at the Regional House of Chiefs. I'm sure you've practiced there. There are inherent challenges with the Houses of Chiefs with regards to legal representation. Can you share with us and also make some proposals to what kind of proposals are you going to make to the AG to strengthen the capacity of officers that practice, especially at the regional bars, at the regional houses of chiefs?
Thank you very much, Honorable Chair. I've done a lot of chieftaincy cases, right from the House of Chiefs at the Supreme Court. So I know most of the matters relating to chieftaincy matters at the regional House of Chiefs. One of the issues has to do with the panel system that we have at the judicial committees. Because the chiefs live in various areas, on each court-given day, they may have to travel to the regional capitals to sit on matters. And the allowance that the chiefs are supposed to be paid, at times, becomes very difficult for them to get same. I know of a practice, whether that practice is legal is something that I think this House may have to look at, where clients are made to contribute towards the payment of allowances of the panel members. That is a challenge. I do not see why a client will go to court and they will say client A pay 10,000, client B pay 5,000 for the judge to sit on your matter. That is because of lack of resources. We need to look at that.
I don't remember, have you observed traditional arbitration proceedings before?
Yes, Honorable Chair, I know about that one too.
Yeah, they pay in Tajomu. So that's what is being practiced at House of Chiefs.
Then there is also issue about House of Chiefs when it comes to counsel. They have various lawyers who assist them in dispensing justice at that level. I know that lawyers within the chieftaincy ministry, or those who work at the judicial committees, are on the same conditions of services as lawyers in the AG's office. But there's a practical challenge here where a lawyer who is sitting with the chiefs, when it comes to voting, technically, on the subject matter, has no power to vote. He only writes the decision of Nananum. The same lawyer will write the majority decision. The same lawyer will write sometimes a minority decision. So this dilemma, that's a challenge. Because the same lawyer has to find authority to support the majority decision and come to the man. So that is something that we need to look at as a nation. Then there is another aspect that I think as a human rights activist that I've seen, that our queen mothers have for all this while not been part of the panel that sit on chieftaincy matters in the various regional House of Chiefs and the traditional councils? I don't know. Our queen mothers are as intelligent and sometimes more intelligent than even we on the other side. Why? Why can't we incorporate them into the panel system? They can also sit on matters. After all, it is said that when it becomes difficult, you go and see the abrewa. But if the abrewa is around, why don't you allow the abrewa to sit in? So you don't, you don't get to that stage. So I think these are the areas that I think we may have to look at as a nation.
That's very, very insightful, Mr. Nominee. Let's go to my last question on citizenship. Citizenship. The Constitution, I think under Article 94, thereabout, bars certain category of persons from holding certain positions. Rushing to get that provision, I think 94. A moment, I'll get it. Yes, 94 3B. A person shall not be eligible to be a member of parliament if he is a member of the police service, the legal service, and also certain category of persons being barred from holding certain positions as diplomats and what have you. Do you think the Constitution is being fair to those category of persons, especially when they qualify as Ghanaians? Chairman, that's my last question, please.
Thank you very much, Honorable Chair. It is true that some category of people are not permitted to hold certain offices under our Constitution. Speaking from what I'm sitting, I see nothing wrong with the provisions. After all, if you want to hold a position as an MP and you own allegiance to allegiance to another country, you allegiance to another country, why don't you renounce it and come and then enter this parliament? Yes, he did it. So far as I'm concerned, so far as there's a possibility for you to renounce, for you to join, renounce and then join. When it comes to voting, you may have the right to vote because you hold dual citizenship. You have the right to vote. But that should not give you the right to enter parliament. That should not give you the right to become the president of the state. If you want to go further, to become the president of Ghana or to be an MP, you need to renounce first and foremost. Because allegiance to Ghana is so key. We do not want a situation whereby you allegiance to Ghana, you attend other meetings, then you disclose other things to other people. So how we have it now, Mr. Chairman, I agree. We should maintain it.
Thank you. Congratulations.
Thank you.
Yes. If you can, okay, I'll give you after that, you can take it.
All right, thank you very much, Mr. Chairman. Honorable nominee. Let's begin with something that I'm sure that colleagues will also be interested in, members of parliament. It has to do with your stated position on ex gratia for especially members of parliament. Your argument, which you sought to get the court to agree with, is that it has to be a one-time payment for members of parliament who will not be returning. But Article 71 of the 1992 Constitution, where ex gratia for members of parliament is captured, does not list or state that it is only for members of parliament, and does not also state that it has to be a one-time payment, because our parliament is structured that after every 4 years there's a new parliament. Now, have you moved from that argument, or do you find the current status quo to be a superior position than your argument, or is something you still hold? And can you convince this committee why you think your position should be the one adopted by the nation when it comes to how we treat the payment of ex gratia, especially to members of parliament who have finished their first 4-year term, or how many number of terms they do?
Thank you very much, Honorable Chair. Honorable Chair, if I may seek your direction on this, I'm aware of a suit titled Elik Plim Agwameva versus the Attorney General, suit number J1/16/2017, which spent at Supreme Court on this Article 71 matter. And may I seek Chairman's direction as to whether my opinion at this stage could be proffered?
Well, you know, as a lawyer, that opinions are always welcome. Sometimes you may influence the review of the judge's decision, but notwithstanding, a matter is pending.
Yes.
Oh, I'm sorry, I thought you said it was.
Yes.
It's
pending. Yes.
Our rule is that you may not comment on matters pending in court in such a way as to prejudice the parties in the suit. So if you think that your comment may prejudice the parties, you'll be guided by that.
Honorable Chair, it will. So I may want this pass over me.
Very well. Honorable Member, please ask another question.
Thank you, Mr. Chairman. I was hoping that
how do you know your position will prejudice the judges?
Because I may conclude, and that conclusion may not be the conclusion that Supreme Court may reach. In actuality, if sub judice, I think it's a bit dangerous to tread along that line. That's why.
Are you sure your conclusion is not one of the arguments that is being preferred by one party in this litigation? In which case, your argument is not strange to the court. The court is seized with that argument, just that it has decided one way or the other.
Honorable Chair, that's the reason why I'm saying if this cap will pass over, yes. I want to stay safe.
Because usually this rule is particularly sensitive when it pertains to the rights of parties in a litigation. But in a pure constitutional litigation where everyone is interested in the outcome, it is actually more beneficial to the court that all opinions are brought on board so that the court can benefit from all the arguments before it makes up its mind on any given position, or whichever way is in the public interest.
Chair, I have opted not to make a public comment on this case. But if I have any position, I may file an amicus brief.
Are you afraid of the MPs, or is it because of not prejudicing the courts?
No, not at all, Honorable Chair, not at all.
Be advised that our rules, our own rules, if I see you making comments which may be prejudicial, I'll rule you. But I think it's still open to you that as a lawyer, you know that commenting on matters which are live may lead you into contempt. And so you may stay safe and stay away from it.
Thank you, Honorable Chair.
Honorable Chair, I am really surprised that the Honorable Nominee suggests that his public commentary will prejudice the case. His public commentary is already out there. He's already made his argument and made his position known. I was just seeking his stance, whether he still stands by those public arguments he has already made, or he has changed from those arguments. That's all. As for the position that he stands as far as this case is concerned, it's already public knowledge. So I just wanted to know if he thinks it should be, if he still thinks it should just be a one-time payment, or it should be after every 4 years. Yes or no?
Honorable Chair, I still want to maintain my position and stay safe.
All right. I'll move from there. I see that the Honorable Nominee is not willing to state a position on this committee as far as that matter is concerned, even though we know his position out there. Now, let me take you to Another case that was quite controversial in this country, it has to do with the power of the president to pardon remissions. Some journalists and social commentators on radio made comments that the Supreme Court found to be contemptuous, and for which reason the court sentenced them for contempt based on Article 1262 of the 1992 Constitution. Some appeals were made to the then president to exercise his power of pardon under Article 72 of the 1992 Constitution, which reads, and Mr. Chairman, with your permission, I would like to quote, "The President may, acting in consultation with the Council of State, A, grant to a person convicted of an offense a pardon either free or subject to lawful conditions, or grant to a person a respite, either indefinite or for a specified period, from the execution of punishment imposed on him for an offense, or C, substitute a less severe form of punishment for a punishment imposed on a person for an offense, or D, remit the whole or part of a punishment imposed on a person or of a penalty or forfeiture otherwise due to government on account of any offense." So here, offense is my emphasis, offense. Contempt, by my lay mind, is an offense. The president, I think, exercised his powers under D to remit the whole or part of the punishment. You challenged that. You went to court. It was a 5-2 decision with Jones Doche and Enini Yeboah dissenting. Maybe predictably, if I should add, but that's just by the way. Now, what were you convinced by the position of the court that you were wrong, or you think that the president in that situation was capricious in the execution of his mandate under 72, because your argument was premised on 296?
Thank you very much, Honorable Chair. Contempt of courts, as we have it in our laws, is a wide area for the courts to go through. And before filing the suit that you spoke about, I held a humble view. If you talk about offense, it relates to criminal offenses. If you talk about offense, it's about a police having arrested someone, preferred charges against that accused person, brought him before a court of law for him to be tried. Contempt, I concede, is a quasi-criminal matter. But if you go to court, you are not charged with a specific offense. But you have the criminal contempt. So I went to court for the court to interpret what's meant by offense in Article 72. And the idea behind this challenge at the Supreme Court was the court to settle once and for all whether a president can at any point in time pardon someone convicted for contempt. Now, if you take the Prison Service Act, when it comes to remission, there is an exemption that remission does not extend to those punished for contempt. So I was arguing that having that Prison Service Act, and also having in mind the fact that contempt is not a criminal matter, then upon a careful reading of Article 72, the offense there should exclude contempt. But the judges, in their wisdom, by 5-2, disagreed with me. I went to court. This house has the power to punish for contempt. So question, if someone comes here and engages in an act that's so bad, and this house decides to punish the person for contempt, should the president have the power to say he's pardoning such a person? That's a key question. So I was looking at independence of the state institutions, but as we have it now, the question has been answered. That contempt is a criminal matter, and for that matter, any other president can exercise the same power in granting remissions.
Right. My emphasis was on the offense, but I think you have explained it well. I think that the Constitution is very clear on what an offense is, and I think it's also defined better in our criminal code. And I just find it interesting that we still had two judges dissented, but like you have stated, it was a 5-2 ruling, and it stands. Now, going through 72, I also took notice of C. Article 72, I took notice of 1C. Substitute a less severe form of punishment for a punishment imposed on a person for an offense. And this is because I have been reading literature on congestions in our prisons, and you are going to be the Attorney General. Deputy Attorney General, sorry. Many have called for non-custodial sentences, and they need to respect the human rights and dignity of even prisoners, given the congested nature of our prisons. The Ghana Statistical Service last put it at about 45% increase, from about 9,000 to about 14,000 prisoners. Question is, based on C, and based on the calls for non-custodial sentences, is it possible for the AG, who is the advisor of the president when it comes to adjudication, to expect that you will support your minister to bring a non-custodial bill to Parliament? That will help in terms of congestions in our prisons. Should we expect that?
Thank you very much, Honorable Chair. I'm aware of the plans by my boss to submit before this House a bill on non-custodial sentencing. But at least, I also took part in a seminar before the bill was even drafted on how we could also decongest the prisons. One of the means is what the Honorable AG may want to bring before this Honorable House for your discussion and subsequent approval. Now, when you go to the prisons, as you rightly noted, you have two categories of people: those who have been convicted and sentenced, and those who are on remand. Interestingly, those on remand are not criminals. They've not been convicted. However, in terms of treatment, theirs is worse, because they lie on the floor. Some of them, sometimes 12, 20, 30 in a room, while those who are criminals, who have been convicted and sentenced, sleep sometimes on mattresses and beds. So there's an issue of human rights, technically, abuse there, because the person on remand has not been convicted. He must be in that kind of dignity. Fortunately, Ghana, per our constitutional architecture, there are provisions on how prisoners should also be treated. And Mr. Chairman, when this bill, as my boss may want to bring this house, to this house, is ultimately approved and passed, it may decongest the prisons. I've also taken part in seminars where we may want to look at plea bargaining, where we may have legislation on how we can engage in plea bargaining. In that case, people may want to take advantage of that system, avoid going to prison. Even though I consider that currently there's an aspect of plea bargaining. If you take our Criminal Offences Act, the Procedure Act, there are aspects of plea bargaining. But if we had that kind of system also, and this House passes it into law, it could be looked at. Then the Justice for All program is a program that the learned AG has told me we want to continue, because that system helps in decongesting our prisons. So, Honorable Chair, these are my views on.
All right. Legal aid, it came up a short while ago. I've been wondering if we can make it a condition, and as Deputy Attorney General, if you agree with me, I want to know how you can support that move. A condition for the renewal of licenses for lawyers. So when a lawyer is going to renew the license, or also to be used for determining lawyers in good standing? How many pro bono cases, for example, have been done in a year? Should be a reason for one's license to be renewed or for one to be considered in good standing? What do you think about that?
Mr. Chairman, thank you very much. I know there are some learned colleagues here. Yes, in terms of procuring our practicing license, that every lawyer may want to have his license without any restrictions. But there are some discussions elsewhere that I think we have to also engage in as to whether pro bono legal services or legal aid cases should be a condition precedent. Now, if we were to undertake the exercise where pro bono cases should be a condition precedent, I would even suggest that we don't go to lawyers alone, or everybody.
Every service provider must also provide some pro bono services.
That's it. Honorable Chair, even if a lawyer may want to join the bench as a judge, we may want to look at that. If a lawyer may want to enter parliament, we want to look at his pro bono legal services. Even president. But it's a conversation we can engage in.
Please leave it there. The Bar Association will make regulations, but very well. All right.
Thank you, Honorable Chair. Honorable nominee, congratulations.
Thank you very much, Honorable Chair.
I know it will be very hypocritical on my part to try and test your knowledge in law. We have practiced together for a long time. I've known you for more than 30 years. And I know your temperament. But these compliments are as of today, Tuesday, 15 June 2021. I know you well up to this point. And I have no doubt in my mind that if you will not go and wear political lens, and you stick to your knowledge in law and your fairness, you will be a very good deputy AG. I want to remind you that, even as I give you these compliments today, I will not hesitate to also whip you in line if you want to depart from how I have known you, how BA bar people behave, and generally how Bono people are fair and good. Congratulations, I wish you all the best.
Thank you very much, my sir. It's well noted.
Yes, Honorable Gaga.
Congratulations, Senior Etua.
Thank you very much.
Chair, he was one of those who inspired me greatly when I was a student at the law faculty. So I would ask a few questions. Yes, Senior. I'd like to find out from you what your position is on the argument which has been going on for quite some time. It engaged the attention of the Constitutional Review Commission, and it's about Article 88, which makes the Attorney General a Minister of State. Some have argued that there is need for us to decouple the two, so that the Attorney General position stands distinct from that of Minister for Justice, so that an Attorney General who is strictly a professional will not abuse prosecutorial powers, as in prosecuting members of, say, the political opposition, and so on and so forth. Senior, what is your view on this?
Thank you very much. I think it's a conversation that was started long ago. And currently, I think people are still discussing it. I think the conversation must go on. But you must also have in mind the OSP, its effect on that conversation. Whether we may so want the AG decoupled from the minister. I don't have a position now because I need to take part in the conversation. And where the majority goes, perhaps I may go there or I may depart from the majority. Thank you.
All right. If you look at Article 21, Article 21 clearly makes the right to assemble and to demonstrate a fundamental right. See there, in recent times, the courts have had occasion to give conflicting rulings relative to what the appropriate procedure is in the application of the Public Order Act. The police have oftentimes headed to the courts ex parte to seek injunction orders against would-be demonstrators. Some courts hold a different view. I had occasion to ask the Attorney General himself this question when he appeared before us for vetting. Now, when you're giving the nod, would you consider an amendment to the Public Order Act to resolve that problem once and for all, so that we have a clear-cut procedure spelled out in legislation with regards to how the court's jurisdiction can be invoked in dealing with matters of public order?
Thank you very much. I've also followed that debate. Now, it is not settled because all the decisions that have come out are from the High Court. And as you all know, High Court A may allow ex parte, High Court B may say, go on notice. But under our laws, there are instances where an application may be accepted by the courts ex parte. I think that we can still maintain it, especially because under the Public Order Act, some people may apply to the police for whatever they may want to do. The police may write back to them. We are not going to afford the opportunity. If we were to use the application where you have to go on notice, they may even go into hiding. You go on notice, you cannot even get them to serve so that you can even go to court to stop them. That's the very reason why under emergency cases, ex parte applications are allowed. So the two systems must operate until and unless a superior court, like Court of Appeal, Supreme Court, comes out with a determination that every application, when it comes to restriction on movement, should be on notice. I think we must still follow what we have now.
In response to an earlier question on the chieftaincy courts created under the Chieftaincy Act, you identified some of the challenges, which includes the same lawyer having to sometimes write majority decisions and write dissenting views at the same time, etc. Now, in view of those challenges, would you support, say, an amendment to the Chieftaincy Act which would scrap the chieftaincy courts as they are constituted now and create, say, some specialized court, create a division of the High Court with a specialization in, say, chieftaincy matters alone to deal with the numerous problems that we have recorded over the period in relation to the judicial committees of the houses of chiefs. I've had very terrible experiences. You attend court and today one panel member is sick. I mean, he doesn't turn up because, I mean, he's taking sides. And these are chiefs, essentially. The chiefs are friends amongst chiefs. So when two chiefs are locked up in litigation, all manner of things do happen. Having practiced the chieftaincy courts, would you support such an amendment?
Honorable Chair, I think this question is an important one, but it's also a contentious one. If we're dealing with chieftaincy, you need to engage the chiefs. Now they have the system where they sit on the case to determine outcomes. And the thinking is that they have such a deep knowledge in custom that when they sit as a committee to arrive at conclusion based on custom. But now, let's take it. Judges also sit in court. They also make determinations on customary law. So it will not be wrong for a suggestion to be made that we look at the constitution of the panel when it comes to chieftaincy matters. As you really suggested, it's possible that after engaging our eminent chiefs, they may agree that a high court judge sits with two of them so that they will support him, the judge, in arriving at the conclusion. It is true that when it comes to chieftaincy matters, most of them delay because Chief A will be in today, the next time Chief B is not in. But if we were to have a sitting permanent court, a chieftaincy tribunal, presided over by a judge, with other chiefs assisting him, it's a way, as I said, it's a contentious one. We need to engage Nananum to know their opinion on it so that a decision could be made.
Sidi, I wish you the best of luck.
Thank you.
Very well. Leaders, who else? Very well. You're acting leader now.
Congratulations, nominee, for your nomination to the prestigious Deputy Attorney General and Minister for Justice post. My focus is on administration of justice, prosecution, and how to enhance the resources available. You have been in private practice, and you see that police officers have tended to prosecute many of the cases at the lower levels of the judiciary. These police officers haven't been to law school. It doesn't mean that they are not good at their job. Some of them have learned on the job. And they are not that many. And sometimes the cases delay because there aren't enough personnel to push the cases. Do you think that it will be a smart thing if we introduce the teaching of criminal procedure and practice as part of the first degree course, and then we will allow the Attorney General's office to engage the products who can then be used for such basic level prosecutorial assignments instead of using police officers for the prosecutions?
Honorable Chair, I think this is a good suggestion that you've made. Because I've checked from a country like Kenya, where currently all prosecutors there are lawyers in Kenya. Moving forward as a state, as you suggested, we may have to aspire to come to a point where even at the district courts, the prosecutors will have to be lawyers. Fortunately, now you have a huge number of LLB students. These students are aspiring to enter into the Ghana School of Law to pursue professional law. I think we can start a conversation whether we may want LLB students to be given some training, but they specialize in prosecution. So that's the career they've chosen. It's something that my Honorable Minister, I think the Learned Attorney General may want to suggest. We will discuss and engage and see whether it's feasible to do so. Most of our police officers, I must say, carry out their duties with the strength that they have. They do their job. I was thinking that since the police has not been fashioned along the line of prosecution, we may have to veer into the other side and get prosecutors who may be lawyers or LLB trained students to do it. So I think suggestion that we may have to engage seriously. It's a serious one that we may have to look at. Thank you.
So beyond an innovation like that, from your experience, what other innovation do you hope to bring to the ministry to enhance access to justice.
Thank you very much, Honorable Chair. The learned AG is here. I'm yet to be assigned a specific role to play. But whichever area that he places me, I'll definitely discharge my duties so that the Ghana project that we are aspiring to build will come to fruition. If you look at the prosecution side, definitely, I don't think if I'm put there, I'll not be able to work. The civil side, whatever area that I'm put, definitely I'll discharge my duties credibly so that the AG, who happens to be also a distinguished lawyer, will succeed in his office as an Attorney General. Thank you.
I hope there's no patronage here.
Not at all.
Assuming you go to the civil division, what will you do about the problem of huge judgment debts?
Thank you very much. Judgment debts. The practice has been that when writs are issued in the regions or even within the nation's capital, the AG's office is served. It is the duty of the agency that's involved to collaborate with the AG. And at times, I think the AG some time ago made a statement that those officers within the ministries who fail to collaborate with the state when it comes to civil matters may have to be held personally responsible. Judgment debts sometimes also arise, not because of the fact that people are not cooperating with the AG's office, but some state actors at times act blatantly. They act negligently. For instance, how can a prison officer taking a prisoner to the court or to the farm place the prisoner in the bucket of a vehicle, of a truck? The prisoner falls. Later, his lawyer goes to court to sue. He has a huge judgment against the state. The state will have to pay. What happens to the officer who did that act? That we need to also look at that. So in terms of civil suits, if I'm taking these are the areas that I may want to look at based on instructions of the learned Attorney General to ensure that at least we bring to the barest minimum judgment debts. Thank you, Mr. Chair.
Now, do you think that given the problem that we have in relation to judgment debts, that we can shift responsibility from the state to the individual actors acting on behalf of the state, so that in a case where it is the negligent or reckless conduct of an individual that results in a breach that occasions a debt, that it becomes the responsibility of that individual and not the state by a legislation that puts the contracting party aware, like buyer beware. Is that okay? That if you enter into a contract with this agency without a clear okay from the Attorney General's office, if ultimately there's civil liability resulting from some breach of the contract, that you can only sue against the individual officers who negotiated and signed the contract and not the state of the Republic of Ghana. Do you think we can shift that? Because sometimes it also looks like there's some collaboration in generating the judgment debts.
Honorable Chair, I think that suggestion is a well-founded one, but Article 293 of the Constitution will have to be looked at if we may want to bring on board the suggestion that you've offered. If you're able to go through that one, then perhaps prospective individuals or entities that may want to contract with Ghana will be put on notice. But so far as we have Article 293, the state is responsible for all acts of its officers. An officer will do it and the state will be held liable. But that's why I was giving suggestion, as the AG also said some time ago, that we must move further. We talk about indemnity at some stage. So, Honorable Chair, I think it's a good suggestion, but we have to look at Article 293.
293 says claims against government. We define what is a claim against government. So if we decide that a transaction like that does not constitute a claim against government. What is wrong with that?
So I said we need to look at it again. It's a conversation we have to look at. It's a conversation we have to engage in to see how best we can go through these processes and then come out with, if any, legislation.
It's a serious problem that we need to look at. Because if you look at the payments from the Treasury relating to judgment debts and what those payments could have done in terms of construction of toilets, school blocks, and fixing bridges in our constituencies. Think about it when you get to the Attorney General's office under the guidance of your boss, assuming you head the Civil Division. Thank you very much.
Thank you, Honorable Chair.
Yes.
Yeah, thank you very much, Mr. Chair. Permit me if I ask, I've not sat through, so if some questions were asked and I try to repeat them, you can draw my attention so that I don't waste the committee's time, because I didn't sit through. I just want you to look at your CV. I think page 2 of your CV. You will see that between Sunyani Senior Secondary School, where you had your A-level, and the University of Ghana, 1995 to 1997, there's this gap. You didn't explain. I haven't seen any explanation in your CV that covers that period.
All right. I think I was captured under national service. Because from A-level 95, I did my national service, and it is captured.
Yeah, so 95 to 96, where you did your service, on the same page too. And then you said people's teacher.
Yes.
St. James Preparatory School, Drobo.
Yes.
96 to 97.
Yes.
Why you didn't go to, you didn't proceed straight from secondary school after the service to University of Ghana?
Because of the strike. We had to stay home for 1 year.
There was a 1 year strike.
Yes.
Mr. Chairman, I want you to look at Article 103. I don't know if you have your constitution with you. 103. Parliament shall appoint standing committees and other committees as may be necessary for the effective discharge of its function. 2 and 3, and probably 6 are where my interests truly are. The standing committee shall be appointed at the first meeting of Parliament after the election of the Speaker and the Deputy Speakers. 3, the committees of Parliament shall be charged with such functions, including the investigation and inquiry into activities and administration of ministries and departments as Parliament may determine, and such investigations and inquiries may extend to proposal for legislation. Do you think there can be any act passed by Parliament that could waive any institution from Parliament's ability to investigate any matter under it?
Honorable now, Parliament has the power to investigate into matters. That's the first thing. But as to which matters Parliament may want to go into may be subject to other factors. If, for instance, there is another body investigating into a specific matter, the Parliament, with all due respect, may not have the power to also go into it. So Parliament may want to activate Article 103, but having in mind the functions of the other state institutions, whether they've also activated similar activities that Parliament may want to investigate.
By this your explanation, are you in any way trying to suggest that the portion that says, as Parliament may determine, a parliament determines that it needed to investigate or to inquire about anything, there could be limitations. Is that what you are suggesting?
Thank you, Mr. Chairman. The use of the as may determine, meaning it's a discretion. But instead of that discretion, you look at the other factors. So there is, in a way, some form of limitation inherent in it. That's why Parliament is given the power to determine, as Parliament may determine. That's how I see it, Mr. Chairman.
Mr. Chairman, then I want to find out, from your practice, I can see that from 2003 to date, you've just been practicing. Tell me an example or any situation that may arise that you think Parliament may have to investigate that an institution has already not been taxed to handle. Because everything that you want to do, Parliament might have passed some act, or there's some existing legislation, or some regulation, or some decree that is already there. So can you imagine that there's some areas that you think there's no any regulation there, therefore Parliament can then step in, because in those areas there's no any institution, there's no any regulation, there's no any existing law, and that's where you think may be the only place that Parliament can investigate. If you could give me an example or a situation that in your long practice that you think may be easier for Parliament to investigate.
Honorable Chair, I don't have a specific example to give, but I think if Parliament decides to investigate into any other matter, or to go into any other matter, it will be the duty of the person being investigated, group being investigated, to raise issues as to whether they think that that matter is pending before another body. And it will be the duty of Parliament to determine. Because it's a discretion. Parliament may want to investigate. The person being investigated may want to raise issues. But decision as to whether Parliament may want to go on or stop it rests with Parliament.
Yeah, so if you look at 6, where the powers of Parliament for enforcing attendance of witness and examining them on oath, like you yourself have been invited here. If Parliament compels anybody to appear, you think that that person, there's any reason why any other person may refuse to appear before Parliament or a committee of Parliament to answer questions?
Thank you very much, Mr. Chairman. Compelling someone is a kind of constitutional power given to Parliament. So Parliament may compel you to appear, but as to what you say is another matter. Parliament has the power to compel you to appear. You may appear, but as to what you say is another matter that the individual may decide. So I have no doubt in my mind that if Parliament summons you, you have no option than to appear.
Mr. Chairman, earlier when he was answering a question about police acting also as prosecutors, and even much earlier he was talking about we trying to get lawyers who even want to come to Parliament or go to be judges. We need to find out. Without, I'm just paraphrasing, not just quoting you. They may have to show how much pro bono they have done, or whether they have served with legal aid. You know that in many advanced countries, whether in the US or in Europe, many of the countries have a system where not only lawyers, but almost every profession, you need to serve voluntarily for some period before you can access some other government facility or positions. In your view, yes, I strongly agree with you if we can do that for lawyers. But in order not to create discrimination, that when I choose to go and be a lawyer, I'll have to do 2-3 years of this. But if someone decides to be a medical doctor, his is different. Someone decides to be a teacher, his is different. What do you think we can do with almost all the professional bodies that will get them to voluntarily serve our country before you can occupy some positions, so that it can fit in very well with lawyers serving either under judges, whether in our courts, whether in the police service, whether in the free aid office, to enhance the delivery of justice in our country.
Thank you very much. Legal aid is something, pro bono service is something that I think every lawyer must engage in. It must be uniform. So it's the duty of the Ghana Bar Association. For that matter, the other bodies, if you come to the medical association, they also have their own scheme of things. All these bodies will have to come together to see how they can fashion out some policies or some rules relating to the practice of legal aid, especially the law side. Now, in some jurisdictions, they use the credit hour system. So if, for example, I want to be an MP, and per the qualification, I need to indicate the number of hours that I have served or have delivered pro bono legal services as one way that we want to look at it. But to me, legal aid now is a commission, and I think the commission, you also need to liaise with other institutions to see how best something could be fashioned out. Mr. Chairman, I think this is what I have to say on this.
I wanted to get your bit about the other professions because, for example, I know in the teaching field, when the national service was introduced, I think in the very early 80s, over the period, it has been one huge source of teachers in deprived areas assisting Ghana Education Service. Because annually, they are guaranteed of getting some large number of graduates that will go into the classroom to teach. And this has served very well Ghana Education Service. And I can see even your CV, you had to teach. I had to also teach after A-level and all that. So it helped GS. I want to get your take. Other professions, what do you think we should do? Should we have a mandatory national service, say 2 years, 3 years, for all professionals, so that lawyers included? Then in the case of lawyers, they will be assigned to legal aid or what have you, and accountants may be sent to other institutions, doctors may be sent to rural areas, nurses. I know now nurses and doctors, I think nurses for sure, also have started doing national service. But the national service is that people fight to stay within the very big communities that already have been oversubscribed. But we all knew that when you were to do national service, they were to take you where your services are truly needed. I wanted to get your take on whether you think we shouldn't move into legislating it instead of the current arrangement where it is so fluid and optional.
Mr. Chairman, I know that students in Ghana after university are supposed to do national service. That's a different scheme. But from what you are saying, it appears to me that the regulatory bodies may need to sit down and fashion certain policies regarding how their members can also contribute their quota to the development of Ghana without taking any fee. I do not think it would be a bad idea, as you suggested, that maybe you have maybe within a year, if you're a medical professional, you need to show that within a year, maybe for a month, you did work for the community for free. Ghana Medical Association may want to take that one on board. If you go to the other areas too, they can also do the same thing. So I agree with you.
Chairman, earlier when he was answering a question about the state actors who act negligently and sometimes put the state in terrible situation that leads to huge judgment debt, he was quoting Article 293. Yes. But don't you think, like Honorable Mama Yaga said, we should move to a stage where even if the contractual agreement doesn't rest with only the state actors, should there be any problem, but persons like you yourself admitted must share part of the blame for the negligence? Because you go across our districts, you go and see officers, especially land, government vested land. They dissipate them anyhow because he knows that the next moment he will just seek transfer and move out of the trouble area And then he or she doesn't care. Yet when the trouble comes, government is forced to step in, and in many instances, government has to spend huge sums of money. Will you, as part of your advice to the minister, maybe advise that we legislate this so that it becomes mandatory, so it doesn't become something that one government may do, another government may not do, or one attorney general may want to prosecute and add the state actors, another may not want to add?
Thank you, Honorable Chair. As I earlier on indicated, if you want to legislate, you have to look at 293 again, so that we don't have any situation whereby there's a piece of legislation, then there's an issue about its constitutionality. We can look at the two and then perhaps come out with something that will benefit the entire country. But state actors acting on behalf of the state, if a state actor goes on his own floric to commit a tort or an actionable wrong, the state may be sued, but the state will not sit down to say, oh, because the state has been sued, the state is liable. Because the person might have gone outside the scope of authority. So all these things are there that are definitely, all actions against the state will be defended by the AG's office to the best of our ability.
Chairman, lastly, I know this area may be a bit controversial for you, but I just want to get your thought. In the case of the Achimota and the Rastafarian students, we noticed that the Attorney General was in court and defending the school instead of the students. What is your take on that? I just want to get your personal view on this.
The Attorney General was sued in the first place because if you are going under human rights, then per rules of court, your Attorney General is a necessary party. If the AG is sued, then you have to defend the matter. So that's the reason why when AG was sued by the students, AG had to defend the matter.
Well, sorry about that. I think I got it wrong. I didn't know they added the Attorney General. But after the judgment, I heard the Attorney General. Of course, it's not on the seats, but this is just to get your take on that. I heard the Attorney General saying that this is a matter he will pursue, even getting to the Supreme Court, because we need to have uniformity. Growing up, in every class that I were, I was a very fair in complexion, other and tall. Others were short, others were dark. Why do we want to use conformity to affect innocent students' pursuit for education and not concentrate on the education, but concentrating on other externalities? I want to know your take as a practicing lawyer, and knowing that you are practicing from the Bono region, where you have a lot of mixed communities. What is your take on this?
Honorable Chair, I'm not oblivious of the fact that this matter is pending on appeal. But maybe if I may add this, if you look at Article 14(1)(e), that is key. Article 14(1)(e) is so paramount that if you are determining the right of a child when it comes to education vis-a-vis religion, that article will have to be unlocked. That's the comment that I can pass.
I'll be happy if you read the 14(e).
If I may read, every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the following cases and in accordance with procedure permitted by law. Then E, for the purpose of the education or welfare of a person who has not attained the age of 18 years. So here, there's paternalism. The state is not determining the rights that a child should enjoy when it comes to education. That's why it's key.
Your understanding of that liberty is to say that you cannot wear a long hair, or you cannot wear a veil, or you cannot be allowed within the school, or you'll be compelled in the school to worship in a faith that you don't believe in. And you think that that is your understanding of this Article 14E? Is that what you're saying?
That is not my understanding. It is the duty of the state to come out with policies, for example, schools, because the Ghana Education Service is there to regulate schools. Looking at 14.1e, the GES may have to come out with guidelines as to how students should behave in schools. So if the state, when it comes to this one, that's what I was talking about, paternalism. The state determines it because the child is below 18. If the state says that you should sleep at 8, you have no right to sleep at 9. The state says that you must wear khaki trousers up to your knee level, khaki shorts. You cannot say you're going to wear a trouser. Because here, it is the state that is determining what the child should enjoy in school.
Well, if that's the explanation that GES needed to give, I perfectly agree with that. And where you have GES, who owns the schools, who runs the schools, tell these authorities, do A, and they say, we won't do A, we'll do B because we have our rules here. You think that is right?
The GES has the ultimate responsibility when it comes to that one. The schools cannot dictate to GES.
And then when you read Article 14, I hope in quoting 14, you always do well to also read it together with 21, where 21 is talking about all persons shall have the right to A, freedom of speech and expression, which shall include freedom of the press and other media, the freedom of thought, conscience, and belief, which shall include academic freedom, C, freedom to practice any religion and to manifest such practice, freedom of assembly, including freedom to take part in possession and demonstration, and the rest. I hope that each time you want to talk about this 14E, you'll be reading them together with 21.
Thank you, Honorable Chair. 21 is subject to 14E, as well as 12.2, because rights are not absolute. You have every right, but look at 12.2, which happens to be the main restriction. Then you come to 14.1E when it comes to the, education of children.
Mr. Chairman, it was just an interesting conversation having with them. I wish him well.
Very much, Honorable Chair.
Yes, ranking member.
Chairman, mine would just be, as I indicated, I know the honorable colleague of mine, I graduated from law school same day with him, sat in the same class with him, and some accounting, as I said. May I take you to Article 15 of the Constitution? So, Chairman, just a few related issues. It is not necessarily your domain, but something that the state, I see you are espousing the state, and in responding to the Honorable Whip, you want him to appreciate that there are times that the state will play the role even of a parent and play the role in upholding and ensuring that those rights are enjoyed by them. But the state has a duty in preserving that. But come to 15, the dignity of all persons shall be inviolable. Then it continues, no person shall, whether or not he is arrested, restricted, or detained, be subjected to A, torture, and Chairman, this is my emphasis, or other cruel, inhumane, degrading treatment or punishment. On the street, you see police slap taxi driver, trotro driver. Punishment. I'm not listening to Chairman for this moment. Honorable Yebua, so look at it. The dignity of all persons shall be inviolable. The dignity of man. Respect him because he is man, son of Adam. Don't you consider the police interaction with innocent persons excessive, and that we need to do something about it? Where do you stand on this?
Thank you very
relative
much.
to the right guaranteed in 15 of the Constitution. Article 15. Thank you, Chair.
Thank you very much, Honorable Chair. Article 15(2)(a) is a replica of the provisions under Convention Against Torture. It has been reproduced here. That convention, Ghana is a state party. And per that convention, Ghana is supposed to file yearly reports on how it has actually upheld the provisions. It is true that you may have some officers who may want to abuse the rights of other citizens, but in whatever that we do as a state, if you are a police officer, you should have in mind that the person that you are arresting also has rights. His dignity is inviolable. And for that matter, I will advise that the police service to take a step to reorient some of its members who may not want to fall in line.
So, Chairman, I leave it there. So, you will advise. I want you to go beyond advice. The Office of the Attorney General and Minister for Justice and the Minister for Interior must accept some responsibilities to school the police, to appreciate the weight of the respect that they should accord persons, because that word, that the person is deemed innocent, gives him the right to be respected. So I want you to go beyond advice. Will you, in advising your minister, collaborate with the Interior Ministry to ensure the respect of this right? Thank you, Chair.
I will do so, Honorable Chair. Thanks.
Just your thought on it. It has not worked for Kenya, but in Ghana, it's on. Amend the Constitution. Why should members of Parliament also double as ministers of state? Article 78 of the Constitution. Kenya in 2010 have tried some amendment to their Constitution, trying to decouple the two. You know the Westminster system of Britain, primus inter pares, the first among equals. What's your thought? You think that Ghana, we should separate it, and why? Thank you, Chair.
Thank you very much, Honorable Chair. By the nature of our Constitution, it's a hybrid type, it's a fusion of the American system and then the British system. I think the concern has to do with the limitation of the president to get majority. Instead of making majority, it can be left open. If a president decides to have majority from parliament, so be it. If a president decides to have non-MPs as ministers, so be it. I think Article 78, we'll have to look at once again. And this one, I suspect that in the 1979 Constitution, something was tried. And having learned from that lesson, this article was fashioned this way. Thank you very much, Honorable Chair.
Chairman, I'm done with my very last for my colleague. Emergency powers, may you refer to Article 31 of the Constitution. And Chairman, if you permitted the nominee to read 31(1), 2, in particular 31(3), Chairman will permit you to read it well. You saw when COVID happened, we saw President Akufo-Addo come to Parliament seeking to exercise this power, which in my view is vested only in Parliament, Article 31(3). So Parliament decided to cede that authority to the President. If Parliament did, that's Parliament's problem. But your reading of it, and Chairman, I just emphasize 31(3). Parliament shall, within 72 hours after being so notified, decide whether the proclamation should remain in force or should be revoked. And the President shall act in accordance with the decision of Parliament. But where Parliament then transfers this power to the executive, where do you stand with your appreciation of the reading of Article 31(3)? You saw the Emergency Powers Act, which was passed for purposes of COVID. You will be Deputy Attorney General, Principal Legal Advisor to government. I want you to demonstrate knowledge on this subject matter, including your view whether what Parliament did was right or wrong. Chairman won't hold you for contempt for this purpose.
Thank you very much, Honorable Chair. I know that this Honorable House passed the Restriction Act. It's an act of Parliament. Restrictions. So Parliament has passed a piece of legislation restricting the movement of people. So the Parliament has done so. I don't think there's anything wrong with it. If it had been done outside Parliament, then perhaps an issue could be made out of it. Then, if you even look at...
Chairman, hold it there.
Sorry.
So, you'll be Attorney General. Come to Article 11 again. I'm not satisfied with your answer yet, but convince me, because it's an act of Parliament, you see nothing wrong with it as you are arguing. Come to Article 11.1. The laws of Ghana shall comprise A, this Constitution, B, enactments as you have referred to. So there is what we call the hierarchy of the laws, which is superior. If you answer, then I'm done. Thank you, Chair.
Obviously, the Constitution is superior.
So why were you emphasizing Act of Parliament?
But
because Parliament passed it, Article 31 is a constitutional provision. So
yes,
respond to that. Thank you,
I
Chair.
think the Restrictions Act was passed having in mind Article 31. That is it. It was passed having in mind Article 31. And this August House, in its wisdom, decided to pass that act, acting at Article 31. Thank you.
I find your argument of you and your classmates interesting. And it reminds me of something on your CV, that you were legal advisor to SRC. Were you a lawyer?
Mr. Honorable Chair, you know student politics. There will be instances where impeachment proceedings were initiated. I remember Honorable Agaga leading impeachment proceedings against SRC president those times at Legon campus. So we were just quack lawyers then.
Very interesting. You're imitating what you hoped to join in. Anyway, I think I'll leave it here. The matters I'm keen to discuss a bit live, so I'll leave them here for now. We thank you for attending upon the committee to answer questions. You will hear from us, but for now you're discharged.
Thank you very much.
that you, Herbert?
I, Herbert Crapper,
swear by Almighty God
swear by Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue
shall
be the truth,
the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Herbert Crapper, you look so fianga, but your CV is big and rich. Fianga. Do you remember, what was it, primary English course, no man in Changa. Herbert, I noticed from your CV that not only are you a lawyer, you have a master's in development finance. You've been a government spokesman on governance and legal affairs from 2018. You've been press secretary to the president from 2009 to 2013. Of course, he was then a candidate, right?
Yes, Mr. Chairman.
All right. And you also have a BSc in Agric. That's interesting. Right. You're a member of the Bar Association, and interestingly, one of your referees is Professor Raymond Tuguba. Interesting. Because they belong to different perspectives of the same divide. Right. Now, is there anything more we must know about you?
Thank you, Mr. Chairman. Mr. Chairman, I believe you have summarized my resume. I also have an LLM in corporate and commercial law, and I have some learning in human rights law as well. And I'm a lecturer at the University of Ghana School of Law. Thank you very much, Mr. Chairman.
Chairman,
Yes.
as I join you in congratulating Herbert Crapper, I see others pronounce it as if there was an M, Cramper. Chairman, may I take him to his CV? Page 2, and probably even on page 2. Your Green Hill International School, you just said 1998, so from what period to what period? And then West Africa Secondary School, 2021, as an academic.
I'm sorry, Mr. Chairman, I would
So
make the correction. And
you put in it, if any, for our purposes. You are in Fordham.
yes, Mr. Chairman.
In New York.
Yes, Mr. Chairman.
Okay, Fordham University.
Yes, Mr. Chairman. Briefly for the certificate in human rights law.
Around the Bronx.
Yes, Mr. Chairman.
Dr. Rokoto's Fordham. You speak for the president, is that right?
Not anymore.
So if you were to speak for him this morning on burning of excavators with your law in mind, does that respect principles of law, does that respect? Thank you.
Thank you, Mr. Chairman. Mr. Chairman, I believe that the Galamsey fight is one that we all have to come together to make sure that we are succeeding with. The President has been very clear that he believes the action that is being taken is to ensure that the fight against Galamsey is successful. And he has encouraged that if anybody is contesting the position, should contest it in the court of law. We would be happy if such a contest takes place. And
must the fight be in accord with law?
Yes, Mr. Chairman, and we believe that.
Even as championed by the President?
Yes, Mr. Chairman.
And that you appreciate that the president is subject to the laws and the constitution of Ghana?
Absolutely, Mr. Chairman. The rule of law dictates so, and every action that is being taken is in accord
And
with
that
the
the cardinal principle of the rule of law is natural justice and equality before the law?
Absolutely, Mr. Chairman. And the president and the government is convicted that
And that
every
do owners of excavators have a right to ownership of them as individual Ghanaian citizens? Thank
absolutely,
you, Chairman.
Mr. Chairman, the right to use the excavators for lawful
Now,
purposes.
Chairman, to the nominees CV, Ghana Bar Association, you know, Chairman, we want to know, are you of good standing? From what period to what period? Have you?
Thank you, Mr. Chairman. Mr. Chairman, I was called to the bar in 2017. I'll make the correction, Mr. Chairman, and update the.
You are awarded the John Evans Atta Mills. I see the Evans lost in the last award. Are you talking of late President Mills?
Yes, Mr. Chairman. The award.
So you should read John Evans Atta Mills Scholarship.
Yes, Mr. Chairman. I think the institutors of the award like to call it the JAMS Award, and I believe in their own thinking they omitted the Evans so that it reads John Atta Mills Scholarship, and we abbreviated as the JAMS Scholarship.
What will be your take? Ghana suffers a lot in the name of judgment debt. One, because ministers are not diligent. One, because ministers will not tarry slowly and allow for value for money audits, assessment to be done. Ministers will not even reach out to the office of the Attorney General, and they just sign agreements. And sometimes condition precedent to it results in the state being burdened with judgment debt, needless loss of money that otherwise can be used for other important sectors of our economy. You want to share your view on it? What can we do to avoid it? Thank you, Chair.
Thank you, Mr. Chairman. Mr. Chairman, I believe that continuous education, continuous sensitization, creating the awareness that the actions have the potential to cause some damage to the state. I believe that the institution that the Honorable Asamoah Boateng heads, the State Institutions and Governance Administration, should take it up to continually train civil servants of state to understand the ramifications of their actions, and as and when they have to consult for legal advice, they should do so. Thank you very much, Mr. Chairman.
Honorable Patricia Pejay.
Thank you, Mr. Chairman. I'd like to add my voice to congratulate my son over here. But you being my son, I still have to ensure that yeah, I want to just declare my
Chairman, do you allow
my interest here.
Chairman doesn't allow breastfeeding here.
Oh no, this one I'm not going to breastfeed. Honorable nominee, there is a lot of controversy about the 1D, 1F program. What is the status of the implementation of the program? Would you say that the vision is on course? Thank you.
Thank you, Mr. Chairman. Mr. Chairman, the 1D, 1F program is a revolutionary vision of His Excellency the President, around which many other programs and policies coalesce into the industrialization agenda of the government. It actually forms a central part of the 10-point industrialization agenda, which is being spearheaded by the Venerable Honorable Alan Kojo Tremating and the able staff of the Ministry of Trade. The idea is to decentralize industrialization, stimulate economic activity in the localities and the various districts, create jobs, add value to our raw materials, promote import substitution, and a concomitant to that will be to promote export and export diversification. The project is on course. There are 76 factories currently running. There are 107 of them that are at different stages of construction. There are 49 of them that have received approval but are yet to commence. Altogether, you have about 232 factories under the One District, One Factory program. In terms of jobs, we understand that the 76 that are running already are creating about 140,000 jobs, direct and indirect, and it is expected that the other 156 when they come upstream too, will produce about 300,000 jobs. This, I believe, is a vision that is on course, and I believe that we should all marshal the support that we can give to it. Thank you very much, Mr. Chairman.
Thank you, Mr. Chairman. I have a very big concern because I see many brilliant government initiatives collapse at our very eyes, often because of the lack of concerted plan of sustainability. I'm very concerned about sustainability, and I want to know, if given the nod, what will be, do you have any ideas to share with your minister for sustaining the 1D, 1F programs? Currently, 76 are running. We have other programs on course. Would you have any ideas on sustainability to share with your minister? Thank you.
Thank you very much, Mr. Chairman. Mr. Chairman, I believe government is investing heavily in the 1D, 1F program and definitely should take a keen interest in ensuring that it doesn't slip like we have seen some other very visionary, useful projects slip. Off the top of my head, Mr. Chairman, I believe that government should take a keen interest in the corporate governance structure of these firms to ensure that there's the necessary diversity, the corporate climate. The firms that are administering these factories should have the requisite capacity to do so.
Honourable Member, let's be clear. My understanding of this policy is that government is a facilitator, that it is actually private sector. So when you say government is investing heavily, I want to be clear. Where is government investing its money? Then you suggest that government should take interest in the management structure or the governance of corporate governance. How will government do that when they are private sector managed or led?
Thank you very much, Mr. Chairman. Chairman, I believe the investment that the government is providing is in some of the incentives that it is giving, and also in terms of the subsidy that it is giving for the interest payment. I believe these are tax holidays, tax waivers, corporate tax holidays. These are all incentives, the subsidy on the interest payment. It's all investment that the government is making. And I believe, I hold the position that government cannot sit back completely to look on for the private sector to, yes, private sector should manage the firms. I believe that government should take a keen interest in the corporate governance structure, for instance, of these firms. I don't propose an interference, but we have the business resources centers and the business advisory centers scattered across the country. I'm just asking that there is a strong linkage between these advisory centers, these institutions, and the companies that are administering these factories. I believe also, Mr. Chairman, that government can organize frequent investor pitches to help attract more investment into the various companies and institutions that are administering these factories. Thank you very much, Mr. Chairman.
Very well. Let me start from here. Yes, Honorable, I'll give everybody space. So start from
So let's just take it from where you are. Do I understand you to be saying, and congratulations on your nomination.
Thank you very much, Senior.
So somebody sets up a factory. Government gives him, the factory is worth, let's say, 100 million Ghana cedis. Government gives him an incentive package, tax holidays, all sort of things that amount to, let's say, 30 million Ghana cedis. You think that the ideal situation should be that the 30 million Ghana cedis should actually be